Marc Bennett.
Brandon Lloyd.
Case United.
Stop with one of my chief investigators in the office. Spoke yesterday.
Correct.
And asked a couple of questions. We want for a copy of the basic plea agreement. The plea agreement itself is contained there. The actual form when it's filed will have a case heading on it, but the case heading, State of Kansas versus Sedgwick County, or excuse me, Sedgwick County Criminal Department will have the case caption at the top of it, but that's the plea agreement.
Okay.
That's the gist of it. Not the gist of it, that is the plea agreement. Did you ask for, you didn't ask me for, but did you want to copy that information?
Yes.
You asked a couple of questions, one about registration. He will have to register in Kansas to be sure. When he gets to Ohio, he should have to register there. I say should because I don't control what Ohio's going to do, but you're supposed to give, it's called full faith and credit. I'm supposed to honor, for instance, convictions from another jurisdiction. We have guys on registration here for convictions in other states. They have to register when they come here. We honor those other states. To my knowledge, every state is going to do that. We've looked up in Ohio, and there's nothing to indicate that they.
There has been nothing in the past that has lead you to believe that they would not honor that.
Correct. Now I'll give you an example. 10 years ago, Scott and I, when he was working in the sex crime division over at Wichita Police Department, adult sex crimes, had a case. It was a cold case, home invasion rape. We had to find the guy with DNA, and by the time we found him, coincidentally, he was in Ohio Penitentiary on a murder. I called the prosecutor up there and I said, so will he spend the rest of his life up there or not? I need to know, because it's going to affect whether or not we bring him back down here and try him here. All she could tell me was, he should. I said, well, then based on that, we brought him back and tried him down here on the rape case here, because I can't guarantee what happens somewhere else. I can only control what's in my lap.
So then why would you let him go there?
He may not be able to go there. That's interstate compact is something else you'll see in that final.
I did speak to a detective that works in sex offender registry in Mahoning County, which is where he would more than likely go. And he said, yes, they are required to do that. They don't always do that. He said that a phone call from me, because you should let me know where he is at all times, being Olivia, being the victim, he has to register where he lives, correct? And you are supposed to let the victim know where he lives.
While he's on paper too, while he's on probation. After
While he's on probation, correct.
I don't get that.
And he said all I needed to do was call him, give him his name and his
We'll do more than that.
address.
We'll send, he'll be on probation here, assuming he's on probation. We're jumping ahead a few things here, but to answer that, he's on probation here. It's an interstate compact there. They supervise for us here. His probation officer here will send the entire package of everything, journal entry of judgment, everything he's convicted of will go there, so they will have a copy of that. He will have a probation officer in Ohio who is doing a courtesy supervision for us here, and then they will notify all the authorities up there. So all of that, everything they need.
This is predicated on them accepting.
They already accepted the plea.
No. Ohio accepting
him.
them for supervision.
So that's why I said we're going to help ourselves.
I understand that.
Assuming everything happens, then he goes up there, they supervise him, yes, and then
Well,
all the information will be there. So
let's go to the go.
So step one is he enters a plea to these 5 counts.
These are the 5 original counts that he was charged.
Counts 2 through 6, correct.
But he's charged with more than what's on that paper.
One more count that's reflected here. The criminal sodomy count is count 1.
And why was he not, when he admitted to that? Why
That's
was
part
he
of the
not?
plea agreement. And then the counts 2 through 6.
So you're not held accountable to the things you admit to?
What's the advantage of him not having that out of the plea agreement?
Because he'll plead.
No, okay, he'll plead.
Negotiation. Here's what we can get him to plead to: level 5s. Level 5s.
Okay. Let me just so we're still negotiating.
There's no negotiation at this point. He's accepted it.
He's accepting
He has
it.
to come to court and do it.
Okay.
Now he could blow it up when we gets there. There's no guarantee. He could walk in and change his mind, and then we're back to trying the thing.
Right.
That happens all the time.
Right.
And if he chooses to do that, then we're back to this.
Okay. But
if
where
he takes
does
the
this
plea-
where does this sit right now? outside of the negotiation.
Still, that's what he's, if you go to the clerk's office right now and say, what's he charged with? That's what he's charged with.
Okay. He doesn't want this.
He didn't want that count.
He don't want this count.
Correct.
Okay.
So
So in order to
negotiation
get rid of this count, he'll
pleads
cop
to
to
the other.
those.
Correct. That's
Okay.
the negotiation. And what he's pleading to.
So what would he get if the criminal sodomy charge stuck
He'd be looking at a 3. So,
instead of a 5?
correct. So ignore this. This is drug count. This is a drug case. These are the non-drugs. So anything that fits on this part of the drug.
So you took the largest one and you pled it out.
Well,
Not pleading it out. He's just not. He's not going to be.
this is his
pleading to
wish. This is his wish.
Count 1 being gone is what
That-
he wants.
that-
That's
that's
part of
his
the
wish.
negotiation. What
Okay.
we get in return are 5 counts.
Okay. Has this happened?
No, hasn't happened. But
Okay.
the negotiation, the agreement has happened. We've had a verbal agreement, and he has to come in next Thursday, I believe, and enter that plea. Otherwise, if he doesn't, negotiations are off, and we're back to putting the case on for a trial.
So if he does say, yes, I want that, this disappears?
Count 1 does, yes. The criminal.
How does that happen?
By pleading to the other counts. I didn't prove, I'll agree that I'm not gonna prove count 1.
But he admitted
He
to
admitted
it.
to it.
Uh-huh.
So by him admitting to this and admitting to all the charges, it's pretty solid whenever you say that you did it.
Sure. And you also then have to still come to court and do it and try the case. Just because you have a confession doesn't mean that you can't. I mean, he has no obligation to come into court. I still have to prove it and put your daughter on the stand. That's the situation here. As I understand it, there was a long 90-minute discussion with you about the problems with putting your daughter on the stand.
There really aren't problems with putting my daughter on the stand.
Well, we can disagree about that. So here's level 5. It's in the purple box here on this particular grid. Blues are presumptive prison, yellow presumptive probation. The purples are what's called border box. He would be a level 5, 34 to 31 months. If he pleads to this, the judge can put him in probation or prison, either one. It's a little legalese here, but it doesn't require departure. To put somebody on probation who's in blue, you have to depart. Judge has to make certain findings.
With the plea agreement, is there a recommendation by your office? What's the
Agreed to send
recommendation?
it to probation, it's set forth right here. You are under you haven't signed this. You are free and you have a right to be heard at the time of sentencing. I think Justin told you this. If you want to come in and say, this is a terrible agreement, we don't agree with it, we're pissed that this was entered into, please send him to prison, you're free to do that.
Right.
And the judge makes that call. And if the judge sends him to prison, well, that's it. He has no right to appeal that. If he
Right.
gives him probation, I have no right to appeal that. Frankly, even if I had agreed to demanded prison, the judge could send him to probation.
He's discretion,
Total discretion of the
under
judge.
his sentencing. I understand.
Counts consecutive, so it'd be 68 months is what would be hanging over his head. If he breaks anybody, if he gets probation, and he violates any condition, he'll do 68 months in the penitentiary. If he had been convicted of the 3, he'd be looking at 61 months in the penitentiary. So it's a level 3 right here. Make sense? And I should have pointed out, he has no criminal history that I'm aware of. We don't show any convictions in his past, so he's a criminal history I. If he had up to 3 or more person felonies, you work your way up this side. When he walks out of court, if he takes this plea, he will be a criminal history A for the rest of his life. He'll be a sex offender with the most criminal history he could possibly have under Kansas law. And it'd also be, frankly, under any other law, they'll show these convictions. They're non-expungible. You can't ever have them wiped away.
Right. He's a registered sex offender for the rest of his life.
Right.
They told me 25 years.
And maybe 25 now you mentioned that. They've changed them all. Some of them are lifetime. I think it's a lifetime for kids under 13.
But when this started, actually I want you to finish that because then that's going to lead to the other things I asked you about. So I'll let you finish what you're doing and then we'll.
So, contact him, and all the rest of these things are set forth here in the balance of the plea agreement.
And then he is also financially responsible for all of Olivia's
Restitution.
And what does that mean by restitution?
It means what the judge decides it means at the time. If you have
I have
counseling-
some of the counseling things and the starts of her service dog. She's going to be in counseling for a very long time. I mean,
So you can give us
continue.
there's not an obligation to, what the judge typically does is say, I'm gonna set an amount right now, and that'll be what's ordered. We can't come back to the judge 10 years from now and ask for more.
Right.
It's, the judge has jurisdiction over it in that moment, so we make the pitch for whatever you want, whatever you're asking for. Let's suggest, if you've got that and those amounts put together, give them to us. and we'll submit them to the court in advance of the sentencing.
But then that's only 6 months of therapy.
Right, but we can also project ahead and get a letter from his counselor, her counselor, excuse me, says we expect it to be X number of, I mean, there's no way to know these things, but this is how these things are done typically. Even if he goes to prison, we'll still ask for it. But we'll say, what is the amount, you know, do you have an expectation within a reasonable degree of medical certainty, counselor, as to how much therapy this person might or might not need? And then they say, I expect it's going to be X number of years, and then you project this of what the amount would be long-term, and they'll ask for that.
So now can she do therapy? Like, so she could do therapy, that's reasonable. What about her service dog?
You can ask.
And then what are things that they normally cover?
Those therapy is primarily.
Therapy, service dog.
You can ask, there's no guarantee that you'll get.
But-
Ask for everything.
So
There's
what
no
are the
guarantee.
other things that we can ask for?
Sometimes people ask for a security system in their home,
Okay.
things like that. I had to change my phone number because my boyfriend who stands convicted, you know, I need the cost of
We already did that, so I can do that, her new phone number.
I'm gonna ask.
Ask for all you want.
Yeah,
Doesn't mean.
shit, doesn't mean a whole lot.
Other questions you asked were registration. I think I told you that. We
Mhm.
expect that I have every expectation he will have to register. I have the caveat that I would with any case in any jurisdiction. I don't control what happens in another state.
So that's what I don't understand, why you would even consider releasing him to another state if you can't control what happens.
Fair enough, but at the end of the day, even if he does his time here, he's gonna go back to that state eventually, so.
Yeah, but then Olivia's 5 years older, 6 years older, she's a little more capable of handling and dealing with some of this instead of being 17 and trying to look over her shoulder constantly.
Okay.
Because how do you prove if he comes back? How do you know if he comes back until he hurts her or he does something to her?
There's any number of ways we could prove that he left the jurisdiction.
Does he have to wear an ankle bracelet? So
Well,
he's,
not unless he has to under another state.
so he
law.
doesn't, so you really have no idea where he is.
Well, I guess I'd point out that that's a true statement for pretty much anybody who's on parole or probation for that matter.
And that's why him being in jail is, because then you do know where he is, and I know he's not gonna hurt my daughter.
Okay. I mean, you're stating the blunt obvious, okay?
But I mean, that's what I'm saying, that it's blunt obvious to me, but the
Sure.
things that are blunt obvious to me, like somebody who admits to all of these things, but then still is not charged, who is not pled out to those, is very.
Counselor, can I just say this with all due respect? You know what bad manner is? Please give us some bad manner.
Fair enough.
Please, thank you.
Well, I will say this, I don't know, if we're gonna be blunt here, I don't know what you're expecting from me. You had 90 minutes with my attorneys, and what I got out of it is, you don't want one of them to ever be in contact with your daughter.
Because
I don't
Monica
think
told
that-
my daughter she had a choice whether to be raped or
I
not.
think that was misunderstood. And I don't believe for a second that Monica meant that. She's been doing this too long I mean, if she said it, she shouldn't have. But I don't think that's what she meant. I think what she meant was what she tried to
What it
explain
came
herself.
across
I don't doubt that it came
after
across
the
that way.
fact?
To give her the benefit of the doubt, especially when you talk about words and sometimes they don't come across, you perceive them as maybe that they come across not as intended. I understand that, I do.
I don't think she would have ever said that.
And I hope she wouldn't.
No,
I mean,
she's
not
too
as a
soft for
human
that.
being, not as somebody who has empathy and empathetic. I don't
She'd have to
believe.
be an idiot to say that to the mother of the victim.
I
mean, just to cut to the chase here, I don't think she's that dumb. I mean, I think she screwed up and she was feeling tense about the conversation and it came out wrong. But for that, I hope she apologizes in the moment. If she doesn't, I'll apologize on her behalf. But let's just back up to the overarching thing here. I went in the sex crime unit in 1999. And between 2009 and 2012, when I became DA, that's what I did, sex crimes unit. Scott is just parent, he happens to be here because he's a detective who's an investigator who's here today. Scott was one of the primary detectives in that unit for over 30 years. Can I prove cases with confessions and with other things? Yes. I still have to put the victim on the stand. I still have to put her through this. And there are times when we look at these cases, especially when it comes to kids, and try to decide what's the overarching goal. There's three things we typically are negotiating over. Misdemeanor versus felony. Registration versus no registration. Prison time versus no prison time. If we're going to avoid putting a child on the stand, which we try to do, We want to get as many of those things as we can. We got a felony here. We got multiple felonies. He's going to be a criminal history A now. It's as bad as it gets. He's going to have the same criminal history, not to be hyperbolic. He'll have the same criminal history as BTK after this plea. He'll have to register. He'll have to be on parole or probation, depending on what the judge does. The judge has, I guess I should point out too, you alluded to it a moment ago, there's no guarantee Ohio's going to want him back. They can say no to it, to an interstate compact, and he may have to stay here, which won't have even more control over him. But frankly, banishment from the realm struck me as a good idea. I wasn't weighing on that at the time, but when they told me that was part of it, if he's going to get probation, I'd rather be somewhere else than here where she's around.
You do know that she's gotten academic scholarships offered from 3 schools in Ohio that she will turn down now.
Okay, I didn't know that.
Because nobody talked to me whenever they did this plea. Nobody said, hey, if he goes back to Ohio, is there any issue with that? There was never any.
Well, I mean, frankly, I understand it, but it was either prison or Ohio, and then the other option is even if he gets prison, he's going to go back to Ohio. I can't keep him from going there if they'll accept him.
But then she'll be through college.
Fair enough. Well,
That's something that you can make the judge aware of.
Yeah.
Okay. That
She has not accepted any offers in Ohio, but she has received 3 academic offers.
and you can make the judge aware of that, and the judge can take that under advisement whenever he goes through the discretionary of sentencing.
Then, where I was now. So.
Well, we were talking about banishment from
banishment
from
the
the
realm. Yeah, that is an old expression. No, the 2 things that are still up in the air is, well, there's 3 things up in the air. He can come in and choke on this and not do it, which happens, like I said, all the time. You know, pleading guilty to aggravated incest isn't exactly something the average guy's going to want to do. Because it's not a guarantee. Well, he's guaranteed to get probation. No, he's not. He's guaranteed to walk in and plead guilty to 5 sex offenses and never wash off. He's walking into a border box where the judge can do, I hate to be blunt here, but damn near anything he wants to do to him.
He has the
Full discretion.
full discretion of
The
it.
judge does.
Yes.
And the judge can send him out for 68 months in prison.
Mm-hmm.
You can walk out and say, no thanks to the district attorney's office, but he got actually more time than he would have if he'd pled to the local 3 and got 61 months. Fair enough. But that judge has that ability. He can also sentence him to whatever he sentences him to, and at the end of the day,
He can set aside recommendations.
yeah, he's not a part of this.
Right.
I sign it, well, the ADA signs it,
Right.
the defense attorney signs it, judges do not sign this. This isn't like federal court where the judge has to agree to
No.
a plea agreement, otherwise it's not going through. So he can screw up the plea by not doing it, number 1. The judge can do what he wants in terms of sentencing. That's still up in the air. And the third thing is the interstate compact. They don't have to take it. So those are all of the things that are still unresolved, and there's no way to resolve them until we come to court and figure them out.
Right.
So with that, but don't judges usually go with your recommendations?
Sometimes, and sometimes they don't. I mean, one of the things we're talking about is how in the recent
often
past.
do they go with them? How often do they not? I mean, you should know those stats.
It's not that simple. Sometimes they'll go with, I'll bounce into the penitentiary, but I'll run them concurrent instead of consecutive. Anecdotally, I can tell you, I think it was Kaufman, just last year, a situation just like this with a sibling gave the guy probation over our demand that he go to prison. And the other thing too is it's 20, that's not it, there's 20 judges in the courthouse, but there are 12, I think, who's sentenced right now. So I could give you stats with regard to one judge, but another judge is a whole different ball of wax. So it's not that simple. But these judges have a lot of discretion over these things.
So we can speak at sentencing.
Yes.
Is Brandon allowed to speak at
He
sentencing?
has to. It's called allocution.
So he
have a
has
right
to.
say
Can
his
anybody
piece.
speak for him on his
Up to the
behalf?
judge. Typically, it's biological family, but it's limited to parents, children, if the person's got kids, or a spouse. Some judges, we used to have a Judge Waller who would let anybody speak. Anybody else got something to say, just open it up to the crowd. Most judges are a little more circumspect. When it comes to victims, there are, the statute requires that parents, siblings, children be allowed to speak of the victim. So if you've got an adult female, her kids can speak, her husband can speak, she can speak, her parents can speak, her siblings can speak. Obviously, for a teenager, it's a different story, but you know what I'm talking about. If you want to submit other letters from her counselors, a letter from teachers or coaches, I mean, I don't know how wide the circle is in terms of people who know about this. You're free to do that. The judge, I can't guarantee will read letters, but you're free to submit those, and we'll ask the judge to consider them. And then again, with restitution, it's obviously not the biggest issue of the day, but anything that you want to submit with respect to restitution, you're free to do that as well. Make sense?
So now to the aspect of whenever I spoke to Monica and I told Monica in our very first meeting, which was about the journal and how she remembered all the other stuff. She remembered dates and times, how she went through everything, and she had all of that she was able to speak to. And Monica told me, no, do not talk to the detective again. We don't need that. We have a solid case.
If it was a journal that was made at the time of contemporaneous with the events, then we would absolutely take that and turn it over. I think that what her rationale is that a journal that was made after something she had just made when she first came forward, that's what's referred to as going to be a prior inconsistent statement, or a prior consistent statement for that matter, but it's not corroborative at the time of, it's simply another statement made. For instance, if she had a journal that she kept when she was 13 and said, last night this happened, that would be substantive evidence we would want to put in front of a jury or a judge to show that she didn't just recently make this up. This is something that she said at the time of. A journal that's made more like after the police get involved, I think Monica's rationale, she explained it to me, was that's kind of between her and her therapist, her and you. It's something that she can, if we give it, if she goes and talks about it, we have to take a copy of it and provide it. It's absolutely discoverable in defense. And if she says something different there than she said in her original statement, then that could be something they could use to attack it. That was the thought process in that statement to you.
Why? But whenever Olivia came forward, she talked about things that happened from a very young age until that summer of 16. But they did not charge him with the things that happened between 12 to 14. Why not?
He would.
And they said they can charge them both at the same time, can't they? In juvenile court and in
two separate cases.
Yeah.
You could charge in two separate cases.
So why was he not?
A couple of things, I guess. The simplest answer would be this: under Kansas law, everything after 2 counts, you can't get any more time. The maximum sentence for any case is double the maximum sentence on the lead count. So in this case, the most he could possibly get would be 61 months times 2. You add a second count of ag incest and a third count of ag incest, we've already got there. 68 months plus 61, you've already doubled that.
But he's doing jail time, not probation.
It wouldn't matter what, well, fair enough, but in terms of a charging decision, at some point you charge the strongest cases, strongest counts up front. If you charge them with 50 counts or 5 counts, after you maxed them out as double the top number, that's all you can get. Okay? For instance, I had a child on the stand years ago. I can remember in a case involving her stepdad, a little Vietnamese girl, and I say that because I remember seeing her on the stand in front of Judge Owens, and I'm talking to her about I've gotten through 4 counts. And I'm getting to the 4th. I got through 3. I'm going to the 4th count, and I start talking to her. She's been on the stand for 45 minutes. She's about 14 years of age, and she is. I mean, the color's draining out of her face. She's sitting there looking at him, and she's starting to cry. And she's, I don't know. And I just stopped. We get to the end of the case. Judge looks at waiting to count for us to just dismiss it. I got 3 counts. I'm already doubled him up. I can't get any more. What's the point? Leave her alone. She shouldn't have to tell more. Every count we charge is one more story. We charge him with what he did in juvenile court. In juvenile court, because he was under 18, the most I could do to him was a juvenile sentence. I could try to map him out, motion for adult prosecution. We have her testify at juvenile court. Under one hearing, we have to have her testify in adult court and in the adult setting. Then we do a map hearing to bring him up. We usually do that as one. That doubles the number of hearings. Then we come up here to get what? I couldn't look you in the eye and tell you that I got a damn thing more than that. I mean, we led with the strongest counts. One thing that I trust at this point is that one of her first statements was, they run together. Pardon me. I mean, detective said, well, tell me about the ones you do remember. And this was her effort to try to come up with some certain things that she does remember.
But then whenever she remembered them, why was she not allowed to?
I understand, but you see, I mean, she could have, but my question is, to what end?
Then there would be all of the information out there.
We still have all the information. She still testified everything that ever happened to her. My point is, why do I'm not being rhetorical, I'm not trying to be an ass, but we filed a 455 motion, what it's called, 6455, to allow the entire relationship of the parties to come into evidence. Tell them she should be allowed to testify anything she remembers. Okay.
But she can't do that now.
She could. Well, she could have done that. I mean, getting back to your first question, why wouldn't she ask to go in and make another statement? Why put her through it? We're going to get all that evidence in if we want anyway at the preliminary hearing or the trial. She can testify about whatever, but we're just going to prove the counts that we're going to be able to prove the most specific ones that she absolutely remembers. Because adding 4 counts, 10 counts, juvenile counts, whatever, I don't get any more sentence out of it. But
She's very upset that he wasn't charged with rape. She is very upset that rape was not on there, and she doesn't understand why. She said because unequivocally it was rape.
Well, I understand.
And so she feels like all of the other stuff was merely just that for her, because nobody's explained this kind of stuff to her, has been that why was he not charged with rape? He raped me.
That was the final question I think you asked me, which is what was said to your daughter during the interview or the follow-up with Justin and the detective. Mm-hmm. I asked Justin, was there any discussion about trial prep, about here's what was going to happen? And his answer was no. He talked about the risks with the case with you present, but with her, all he wanted to talk to her about was, how are you doing? What do you want? What is your idea of justice? What do you want out of this? She goes, I want to be away from him. I mean, and just goes, okay, well, and I'm not in any way putting this back on her. I mean, she can be pissed if she is. I'm sorry, but to answer your question, he didn't go over the case with her. He didn't say anything about her being made to look, in your words, like a whore. That was not discussed.
Those were his words he used to me.
Okay, well, fair enough. I wasn't in the room. If that's what you say, he said.
I got lots of people that heard it.
My point is that they didn't discuss the case in terms of what the defense was going to be, or here's how the questions are going to be run, or anything like that with her. It was, what do you want? Without your mom in the room, what do you want us to do here? That was the conversation with her.
With all due respect, she is a minor.
Understood.
I don't care what she wants.
Fair enough. But my point is, she has a right to be heard.
She does.
And that's all that was.
But that decision.
The decision's ultimately going to be mine. It comes on my name's on the door.
You're the one that has to answer to the people.
Huh?
I understand
and
that.
So, I have an obligation to. I guess you can say I don't have an obligation to talk to a minor. I think I do.
No, not.
I'm not arguing with you.
No,
I
do, and I don't. I'm trying to choose my words so I don't get misconstrued or anything else like that. It's just yes, she says I just want to be away from him. Okay, well we can play the same thing on words. That's not what she meant.
And I'm not saying that.
Yeah, I know.
She's totally cool with this, and you guys are making a big deal. She thought it was great. I'm not saying that.
But
her question, her question to me yesterday was, what was said to my daughter? I told you I'd answer that question. That was all that it was. Not here to argue that Olivia,
I'm just trying to, I understand the bus has left the station. This didn't get on the bus.
Correct.
This is where we're ultimately going with the judge, and the judge is going to look through here. Granted that he decides to sign the ticket and get on. If you don't sign the ticket and get on,
yes,
we go right back to where we're going. But let's be realistic. This is a sweetheart deal.
You might think so. I mean, to me, you bought off on.
Yeah.
If you're him, you bought off on being a sex offender the rest of your life. You look up his name at any point in the future.
Sure.
You're going to know the word ag incest is associated with you.
Sure.
Sure. That's a lifetime sentence.
It is. Yeah.
Whether he does 4 years in prison, 5 years in prison, or no years in prison.
This guy was one of my students. Okay, I taught for the Department of Corrections in the state of Pennsylvania. I know what sex offenders, and I know the gamut. Okay. Knowing what happens, I'd rather him be in jail because it is what it is.
Sure.
But he's going to take this. Okay, I know, and Monique, He's going to take this.
I know.
Okay. So when he takes this, okay, what we got to focus on is what can be said to the judge, because it's all right to
Right, say what you want.
say what we want to the judge. He's got to sign up, or when's the day where he?
Next Thursday, I believe, is the date that was set.
Next Thursday.
Then when's the sentencing?
That'll be set by the judge at that time.
Okay.
In the judge's calendar.
So when the sentencing is when the family has the opportunity to speak, and we don't know when that is.
No, that won't be set until the judge.
Next Thursday. The only action can happen on Thursday is he says yes or no.
Up or down. Correct.
That's the only thing going. And
I
then-
mean, if the attorney calls and says, I'm home with the flu, can we do it tomorrow? If that happens, we'll call you. But I mean, I'm trying to make sure there's
Right.
no.
Yeah.
Give me a caveat.
No, I'm not.
saying.
I'm not looking.
But
I'm
in
just,
terms of substantive, what's going to happen? Thumbs up or down?
right. And that's up to him.
Yeah. I mean, the final thing I'll say is this, and you can walk in and go, stick in here, but having done this for 23 years, having tried these cases for over a decade, I know what it's like. I've never been on the stand in that situation, but I put hundreds of people on the stand in that situation. Kids as young as 4, Oakland as 97. It is, I don't care if the guy confessed, I don't care if the eyewitness, it's still a hell of a thing to put somebody through. And if you can get something that's damn close to that, that gets close to justice for them.
Which is freedom in Ohio.
If you can, again, I'm trying to be nice bedside manner. I don't expect you to agree with anything I'm saying. It's clear walking into this conversation that we are never going to come to an agreement on this. Fair enough. You want to know why we did what we did. Is this enough? Do you think this is enough? No, but the point is, he has a presumption of innocence, but I have to overcome. I have to make this make sense to a jury, okay? Justin has explained to you some of the issues in the case. You may think they are not issues. That's fine. I would only point out there's a reason why doctors don't operate on their own kids, because they're not going to be objective. I don't know your child. No one on that jury is going to know your child. They're going to look at this objectively, based upon what they hear in court, and how consistent she is and what his explanation may be. And it may be that, yes, he's guilty. No one's going to say he's not guilty. The question is, what's he guilty of? And if I can't prove beyond a reasonable doubt that this was involuntary, that her will was overcome by force or fear or duress, not duress is actually one of the words, then the fallback is ag incest. We could go through all of this to have him convicted of exactly what the plea agreement was. That was our backstop. We're not going to go any lower than that. Now, you may be pissed that we did it. Fair. But that's the rationale. You can say it's a bullshit rationale if you want. Okay. But at least you heard it from me why these kind of negotiations are entered into. Right? I'll answer any more questions, but I think, I'm being presumptuous here, but I think I've probably said as much as is going to be of any benefit to you at this point. If you have further questions, let me know. Otherwise, I'll see you a week from Thursday. Okay?
Thanks, sir.
Okay.
Thank you.